Can I get a design and utility patent on the books? I don't believe a copyright will protect me because anyone could copy the technique. The same technique can be used to teach other high school math and science subjects to elementary students. Cool. Okay. Well, my first hunch is that if you've come across a teaching style, a method of teaching math, right? Teaching them algebra, and it's a process that may be eligible as a method or a process. If you've got it down to, using math terms, like a lowest common denominator number of steps, sort of core number of steps, and that sure you could add, 100 other steps to add on to it. But if there were a core set of things, principles, and order operations in order to get them to learn and absorb that material, it's possible that a teaching method is eligible as a Type 4 process or method patent. The question is that the best way to enforce your rights in terms of what your overall goal is? Okay, and so going forward with a patent, the goal is monetary, right? The goal is to make money. And so if your goal is to make money, you got to make sure you think through the business plan of what you're going for. And so if you are, hoping to have exclusive rights to that method individually, you've got to make sure, obviously, one, that your employer doesn't already have rights to what you're creating. And some folks that have jobs in a public institution, certainly within a large private company, you will be obligated to assign all your inventions to your employer. So first of all, make sure that is true. But assuming you are an independent teacher, or you've got no employment contract that would obligate you to assign your inventions, you then think, okay, well, if I'm the only one that's able to practice this method, is it going to serve me to grow a company and start a curriculum based on this method that I've come up with and enforce your rights? Then the following question is, okay, will you actually be able to tell if someone is infringing your method, right? And that is a hard thing to do for most methods and processes, is from the public's perspective, right? You've got a competitor, Mr. and Mrs. Teacher X, that has somehow gotten what got your formula, and they're using your method. The trick will be, can you tell from your public perception, or maybe from speaking with Mr. or Mrs. Teacher X's students, that they are following your patented method? So that's the question. It's the reverse engineerability test. Will you be able to tell from the outside that the infringer is using your method? And if you think you can, if there's some definitive markers or things that are mentioned and it's definitive, then I think it is worth going for patent protection. If not, and it's tenuous, and you're not quite sure if it'd be easy to enforce, I would advise you to go toward the path of copyright. Okay, and I would encourage you to think about copyright in terms of what's written, right, in a physical book, in digital format, and can protect individual artists that are creators of curriculum, and that is generally the sort of the go-to for most curriculum-based teaching methods, is relying on copyright. And copyright does allow you protections for actual written work and prevents reproduction of the actual work, okay, and also derivative works. And there's some complicated terms with derivatives, but it does mean basically a change or a subtle modification to that original work. You would also have ownership of that, okay? So Harley, looks like you have all the rights on your own. You've conducted the research yourself. Well, that's really good. Well, I think that's as far as I want to take it for now.